Morning again, Your Honor. I want to first go over the law that we must use during this hearing. We're here today because of the case of Miller versus Alabama. That's a U.S. Supreme Court case from 2012. They held that juveniles facing the most serious penalties must be individually sentenced, and courts must have the opportunity to consider mitigating circumstances. Those are chronological age, family and home environment, circumstances of the crimes, not the facts, but the circumstances, incompetencies associated with youth, and the possibility of rehabilitation. We also look to Montgomery versus Louisiana, a U.S. Supreme Court case of 2016. A lifetime in prison is a disproportionate sentence for all but the rarest of children, reserved for those whose crimes reflect irreparable corruption. 2021, People versus Bennett. They state that nearly every situation a sentencing court is asked to weigh in on the appropriateness of a life without parole sentence will involve heinous and oftentimes abhorrent details. The fact that a vile offense occurred is not by itself enough to warrant the imposition of life without parole. A court must undertake a searching inquiry into the particular juvenile, as well as the particular offense, and determine whether this is the truly rare juvenile for whom life without parole is constitutionally proportionate. And most recently, in People versus Taylor, the Michigan Supreme Court held in 2022 that when a prosecutor seeks to impose life without parole for a crime committed by a juvenile, the prosecutor bears the burden to rebut a presumption that life without parole is a disproportionate sentence. The standard for rebuttal is clear and convincing evidence. Clear and convincing means that the evidence is highly and substantially more likely to be true than untrue. Your Honor, this hearing is not like something that we are used to. Usually when the prosecutor and defense stand before the court, we're here for a trial. And in that scenario, the prosecutor has to prove each and every element beyond a reasonable doubt. This hearing is distinctly different. Mr. Crumbley has already pled. He raised his right hand. He told this court that he was guilty of committing all 24 counts against him. We are here today because the people filed a motion for life without parole following that plea. We must move away from the trial mentality and into a sentencing phase. The facts of this case are difficult, they're unpleasant, unnecessary. The images that you will be shown are not something you are ever likely to forget. But through the evidence, through the witnesses and our experts, we believe that the court will agree that the people are not able to meet their burden in rebutting the presumption against a life without parole sentence. The experts and witnesses that will come before you will not give you an excuse for Ethan's actions. They will give you an explanation as to how Ethan ended up with a weapon in his hand on November 30th of 2021. As Jillian Peterson, a nationally recognized expert on the psychology of school shooters, concluded when called by the people at a Daubert hearing in the case of Jennifer and James Crumbley, there is a common misconception by the public that mass shooters are evil monsters who simply snap and commit a shooting one day. At the end of this hearing, we will be asking for the imposition of a term of years, because it will be clear to you that 15-year-old Ethan Crumbley is not one of those rare juveniles that is irreparably corrupt and without the ability to be rehabilitated. Thank you very much.
Thank you.